Good morning, everybody. This is Heidi Simpson with the Leading Age Minnesota staff. Welcome to today's webinar, Emergency Families First Coronavirus Response Act, What Aging Services Providers Need to Know. Thank you so much for making the time to join us today to learn more about this important topic. Before we begin the formal program, there are a few important announcements I'd like to make. The PowerPoint that is before you is something you received as a handout, so you can follow along and take notes. We also, there are a lot of folks participating today, but you can, if you have a question, and I'm sure there will be a whole bunch of them, you can type it in the question box and then send it to the presenters. There will be time at the end of the program to address the questions, and we will get to as many as the time allows. This program is also being recorded, and if all goes well and the technology got to cooperate on this April Fool's Day, we'll have a recording of it on our website for you to access. Sometimes very important information is helpful to listen to more than once, so we want to provide that to you as well. After the program and later on today, we'll be sending you an email with a link to a short feedback form. We'd appreciate if you could take the time to fill it out, particularly in these challenging times. We want to be able to do a good job in staying on top of what you need, information that might be helpful, education that you would find useful. So we will use that information to better meet your needs. So I'm going to introduce the speakers for today's webinar. We're just so pleased that they were able to join us virtually. We are all in our separate places, and I'm going to introduce them in order in which they're going to be speaking. The first presenter is Teresa M. Thompson. She's an attorney and shareholder with our business partner member law firm Frederickson and Byron. They're based out of Minneapolis. In her work, she advises clients in a variety of industries, including healthcare, mental health, disability, and aging services. She works with them on day-to-day employment and business issues with the goal of reducing or avoiding the expense of litigation. Clients consult Teresa to obtain an objective view of employee performance, discipline, and termination issues. And that's her area of work. Following Teresa will be Brian Bengstein. He's also an attorney and shareholder with Frederickson and Byron and a colleague of Teresa's. He's a seasoned litigator and counselor who represents just employers and businesses. And he advises employers on discipline, terminations, and employment law compliance. One of the areas of expertise and experience that Brian brings to his work is he has actually worked in healthcare. He served in a variety of managed positions for a healthcare company that operated facilities in the Twin Cities metro area. And he uses that experience when litigating cases and helping clients. So Teresa, I'm going to turn it over to you.
Wonderful. Thank you so much, Heidi, and welcome everyone. I'm going to walk us through the agenda that we have today, and just to give everybody some idea, Brian and I have been dealing with a lot of COVID-19 related issues for clients over the last several weeks, as you can imagine, and we've tried to frame up this presentation to address a lot of the questions that we have been seeing from clients and following some of the guidance that's been provided. So we're going to start off with a discussion of the Families First Coronavirus Response Act, the FFCRA. We'll move on to talking about when employees can return to work if they have been exposed or potentially exposed to COVID-19. We will talk about continuity of services and employee staffing, and by that we mean issues with recruiting and hiring that you might be facing, and also if you are faced with any furloughs or layoffs. And we'll end with talking about health and safety considerations relating to COVID-19, and particularly with regard to the provision of PPEs. And as Heidi noted, we will have time for Q&A at the end of our session. So let's jump right into the Act. So the FFCRA's effective date is today, April 1st. For a while, we all thought it would be April 2nd, but the DOL issued guidance that said that it was today, April 1st. This act is not retroactive, and by that we mean that any benefits or any paid leave that's been provided prior to April 1st cannot be counted toward an employee entitlement to leave under the Act. And the effective date runs from today and it ends on 12/31 of 2020, at least right now. And so what does the Act do? It makes a couple of very big changes and provides for two different kinds of emergency paid leave. The first is emergency paid FMLA leave, which can only be granted for one reason, and we'll get into those reasons a little bit later, but it's important to know there's only one reason for FMLA. And then there's the emergency paid sick time leave, which also provides paid leave, but for 6 reasons. So it is much more expansive than the leave provided under the FMLA. And who does it cover? Well, the big thing to know is that it covers private employers who have less than 500 employees. And the important thing to note about the 500 employee count is that we're counting employees a little differently than we typically do for most employment laws that you guys are used to dealing with. We count all full-time, part-time, temporary employees, employees who are on leave, employees who are being loaned to you by a temp service. You count any employees who are providing services to your organization to determine if you fit within the less than 500 count employee number. You also need to consider whether or not you might have employees through affiliated entities. And if those entities are considered joint employers under 2 different tests, the joint employment test under the FLSA or the integrated employer test under the FMLA, those employees may be counted toward that 500 number as well. And it is an important thing to determine if you fall under the 500 employees or if you're over the 500 employees, because if you provide paid leave and you're determined to be over 500 employees later, you might not get that tax credit, which is one of the big benefits for employers underneath the Act. So seek legal counsel if you're close to that 500 number to make sure that you know which way you fall. There are also 2 possible exemptions under the law. The one relates to a small business exemption, which is for employers who are less than 50 employees, and the other is a healthcare exemption. The important part about the small business exemption is that it only applies to one component of the reason for emergency sick leave or expanded FMLA, and that relates to school or place of care closures, not for COVID-related illnesses. So, and there are some steps that you need to take in order to fit into that small business exemption as well. And those are outlined in the Q&A that has been issued by the DOL. The one that I imagine is the most important for all of you is the healthcare employee exemption. And we just received guidance on March 28th from the DOL in the form of the Q&As, which many of you are probably familiar with, that gave us the definition of healthcare employees who can, the employers can choose to quote unquote opt out of eligibility for benefits under the FFCRA. And so in that guidance, the DOL defined a healthcare provider quite broadly. And I'm just going to read it to you because it surprised many of us. And it reads, anyone who is employed at any doctor's office, hospital, healthcare center, clinic, nursing facility, retirement facility, nursing home, home healthcare provider, etc., or any similar business. And so I think for all of you, this means that most of your facilities are likely covered. Assisted living facilities are not specifically listed, but I think would fall under the catch-all. And I assume we'll probably receive some more guidance, or perhaps Leading Age is already seeking additional guidance to find out whether the assisted living facilities fall under this exception or not. The important thing to know about the healthcare employee exemption is that it is elective. And by that we mean that you can choose to have employees opt out, or you can choose to provide them with the benefits. And the guidance actually states that it really should, you should try to take an expansive view of the application of the FFCRA And so we are recommending that you address this on a case-by-case basis with your employees to determine whether or not you can, as an organization, provide them with these benefits, and whether you can operate without some of your employees during the period of time when you're trying to care for your residents during the COVID-19 pandemic. And there are some risks of opting out, and I think, Brian, you've been dealing with this quite a bit for your clients, and maybe you can walk our attendees through some of those risks.
Yeah, thanks, Teresa. This is Brian Bankstein, and that's correct. I have been talking with clients about this healthcare exception, and as Teresa noted, first and foremost, it is at your option. So if you are a healthcare provider and wish to provide the Families First Act benefits to employees, you may do so. And when we're talking about there being a risk of opting out, it really relates right now to the fact that with really a lot of these things relating to the Families First Act, both the emergency paid sick leave component and the expanded FMLA, we are operating off of, I would call it a very loose set of guidelines. In other words, the Department of Labor, to their credit, has been issuing guidance in the form of questions and answers that address some of these issues, including the healthcare provider exemption. And you know, as it stands right now, what we have up on the screen is the DOL's current interpretation of a healthcare employee that may be excluded by you, a healthcare provider. The risk, though, is that if the DOL, the U.S. Department of Labor, subsequently narrows their definition of who an exemptable healthcare provider is or a healthcare employee is, you run the risk of potentially opting out of providing benefits that the DOL says that you should have provided. So I can say that I think it's unlikely that the DOL is going to back off of their current Q&A guidelines when they issue regulations. But as it stands right now, I think it would be reasonable for you to rely upon the current DOL list of excludable employees, and you make your best decision at that point. The other thing that's a little unique about this healthcare provider exception is that the DOL's current guidance indicates that you can make these opt-out determinations literally on a case-by-case basis. And you can decide to grant the benefits for one particular person, you can deny them for another. And that is really a very foreign concept when it comes to employment law, in the sense that, you know, we always preach that you should be consistent in your approach. But in this instance, the DOL, at least at this point, has said that you can make these determinations on a case-by-case basis. Teresa, I'll turn it back over to you.
Thanks, Brian. And one other thing to note on the healthcare provider exception too is that the one thing that surprised most of us when the DOL came out with this particular guidance is that it didn't limit the exemption to actual healthcare providers, meaning those who are on the floors providing the services to patients or residents. It expanded it to anyone who is employed, which we are reading to include any employee who is employed by a healthcare provider. And so I think that is much more expansive, and I think that too is where questions may come into play, because if something changes down the line, which really leads us to our next slide, and relating to, now that we know what, where, or who it applies to, when it applies, and what possible exemptions there are, the real question is, where do we look to find out how we apply this act? As you can imagine, the act itself is not written in a way that provides all of the answers. And so, as Brian pointed out, so far, all we have is the DOL guidance in the form of these non-binding Q&As. Those are not regulations, which is what we typically look for to determine how to comply with a particular act. but it is all that we have right now. And the downside is that while they are very, very helpful in how the DOL is currently viewing the new laws, the DOL has already changed previously issued guidance. So to Brian's point about there being some concern that these might be changed down the line, that has already happened before. And so what we are doing as legal providers is making sure that we are checking the DOL.gov website at all times to go back and look at even answers that we've previously reviewed to see if there are any changes. Because what we don't want to have happen is to have clients provide the leave benefits and then have the DOL subsequently modify the interpretation of the act and then try to deny employer eligibility for the tax credits. So looking at that, when will we have some more definitive answers? Well, as with anything, the DOL is scrambling to respond to very quickly enacted legislation, and the DOL has stated that regulations will be forthcoming. Originally, we thought that we might have those regulations by April 1st. Obviously, April 1st is here. We don't have them yet. So timing is relatively uncertain. We had a sense that perhaps they'd be provided by mid-April, and if that happens, we will certainly be issuing updates, as I am sure Leading Age will as well, about how to interpret the new regulations and if they differ at all from the guidance. But for now, I think the Q&A guidance is the best place to look for answers to questions, and I have found that as they supplement those Q&As, they've been answering specific questions that we've been hearing from clients pretty regularly. So they are helpful, and they are what we have for now. So let's look at what the actual provisions are of both the expanded FMLA and the emergency paid sick time. As it relates to the expanded FMLA, there are a couple things that you want to be sure you know. First, who is an eligible employee? For the expanded FMLA, the employee to receive benefits must have been employed at least 30 days. This is obviously different from traditional FMLA requirements, and so that's the first thing to note. The leave that is provided under the expanded FMLA is leave up to 12 weeks for care of a child because of a COVID-19 school or daycare provider closure. And that is the only reason for the expanded FMLA coverage. We have had many clients ask questions regarding whether or not the expanded FMLA applies to a COVID-19 illness for the employee or caring for somebody who has an illness, and the answer is no. It is only applicable if an employee is unable to work because they must care for a child whose school or daycare provider has closed. And what does the expanded FMLA provide? Well, it provides for paid time after 10 days. So the first 2 weeks of that FMLA is unpaid. And then for the remaining 10 weeks, they get 2/3 of their pay, capped at $200 a day for a $10,000 total. But please know that that doesn't mean that every employee will receive $10,000. It means that that is the most that can be paid to any particular employee, but the amount, the total amount, will be based upon that 2/3 pay for the 10-week period, or for however long they need the expanded FMLA. All right, so as to emergency paid sick time, what are the terms there? The difference between emergency paid sick time and the expanded FMLA is that eligible employees are any employees, and it is available immediately upon hire. And you can imagine the reason for that is because the emergency paid sick time is really intended to provide for paid sick leave so that employees can be absent from work in order to seek treatment and to be in quarantine to avoid the spread of the coronavirus. And so it makes sense that it would apply to all employees, even if immediately upon hire. And it applies to employees who cannot work or telework, and we have that in bold for a reason, because of a qualifying reason. And so what we mean by telework is if an employee is diagnosed with COVID-19 or they're in self-quarantine because a healthcare provider has told them to be, but they can still work from home, they're not eligible for paid leave because they are actually still working. And so this may come into play where an employee is still able to completely function at home and complete their services, and they're getting paid for their work instead of being paid the emergency sick leave. All right, so I told you at the very beginning that there were 6 qualifying reasons for paid sick time. The first means is a quarantine or isolation order that comes from the government. And this does not mean a stay-at-home or a shelter-in-place order like the one issued by Governor Walz. So that's important to know. The second is self-quarantine because a healthcare provider has directed the employee to self-quarantine. For example, a healthcare provider tells an employee that you are in a high-risk population and you should self-quarantine, or a healthcare provider says you should self-quarantine because you've been exposed, for example, to somebody else. The third reason is if you are experiencing COVID-19 symptoms and you are seeking a medical diagnosis. And this may mean that somebody has a fever, a cough, shortness of breath, and they are trying to seek a medical diagnosis. But in the meantime, because they have those symptoms, they are staying home at work to avoid the spread of COVID-19 and seeking some kind of medical diagnosis or care. The fourth is caring for somebody who falls under number 1 or number 2. So it also applies to caring for somebody. Emergency sick leave also applies for caring for a child because of a school or provider closure, and this can run concurrently with the expanded FMLA. So the first 2 weeks of that FMLA would be paid under the emergency paid sick time, and then the rest of the time would be paid under the expanded FMLA. And then number 6 is more of a catch-all, which is that an employee is experiencing conditions like COVID-19, but it's not COVID-19, but they are not working as a result. So those are the expanded reasons for the emergency paid sick leave possibly coming into effect. So what are the pay provisions for the emergency paid sick leave? These are a little bit different than the FMLA. The first is that for personal reasons, meaning reasons 1 through 3, that you personally are staying home, you get 2 weeks or 80 hours of pay capped at $511 a day. And remember, that is a cap, meaning a maximum, but it is based upon the employee's average pay during that period of time. For part-time employees, you actually look to see what the average hours would be in a 2-week period, and that's how you determine the number or the amount that they are paid for that time off, but it applies to both full-time and part-time employees. For number 2, the reasons for caring for others, situations 4 and 5, or a personal condition similar to COVID-19, but not, so reasons 4, 5, and 6 of our previous slide, they are paid at 2 weeks of 2/3 pay or capped at $200 a day, which is the same as the emergency family medical leave. So again, it is important to document when an employee is going out on emergency paid sick time, what the reason is, so that you can make sure that you are paying them appropriately and then applying for the credits appropriately. One of the other key questions that we have been receiving is, how does the FFCRA interplay with existing PTO or sick leave policies? And there's one significant rule there. Many clients have asked, can I require my employees to use their own accrued leave first? And the answer is very clear that you may not. So as an employer, if you've got an eligible employee, you must permit them to use the emergency paid sick leave first, and you cannot require them to use their own accrued leave. The other key thing here is that if you have provided leave prior to April 1st, number one, you can't offset that against their 80 hours of entitlement to leave, and you can't claim a credit for that. And you certainly can permit them to use their PTO or their sick leave that they might have already had. And that is probably likely what many of you have already done, waiting for this act to go into effect on April 1st. So any leave after today will obviously fall under the act. All right, so what about intermittent leave? There have been many questions about whether or not an employee can take this leave on an intermittent basis. Or said another way, does all of the leave need to be taken all at once? So the answer here is that it really depends on the reason for the leave, number one, and two, on whether the employee can telework. So in one instance, if the employee is able to telework, they may take intermittent leave in any increments with the employer agreement. And what we see coming about here is likely to be a situation where an employee is working from home and their spouse is working from home, their children are home, and they are asking for emergency family medical leave because they are required during part of the day to assist in the care of their children, but for part of the day, their spouse may be caring for the child. And so with employer agreement, again, the employee and the employer can work out that they will work a modified schedule, for example, and provide services during part of the time, get the paid leave for part of the time while they are caring for their child. Another instance that might come up is if the employee needs to work at the usual work site, meaning they are not working remotely, then the intermittent leave can be taken in full day increments, but only if due to school or childcare closure and with employer agreement. So that means that if the employee is working on site and they are required to be home to care for a child, that they can do that on a full day increment basis. It is not available for times when an employee is subject to either exposure to or infection of the COVID-19 virus. And of course, you think about that, the reason for it is because the intent of the leave is to ensure that employees are not at work to avoid any continued exposure to other employees. So what about layoffs and furloughs? This is another question that we have been receiving pretty significantly, and we received an answer from the DOL in the form of the FAQs on March 26th. And this relates to whether or not, if the work site is closed at any point in time, either due to lack of work or because of a shelter-in-place order, for example, would the employees be entitled to emergency sick leave or emergency FMLA? And the answer is no, because the closure is not a result of a qualifying reason. It is a result of lack of work or a government shutdown. And the same thing applies if the work site remains open, but some of those employees are furloughed due to lack of work. All right, Brian, I think I'm passing it off to you.
Yeah, Brian Bengstein here again. I'm just going to highlight a couple of examples here just to hopefully illustrate how the emergency FMLA works as well as the emergency paid sick leave. So scenario number one, we have an employee who has a child whose ordinary daycare or school has shut down because of COVID-19 issues and remains closed for 6 weeks. The employee has to stay home with the child and can't telework during this time. What leave and pay is the employee entitled to? Well, this is a situation that because we're dealing with a child care closure issue, It's a qualifying reason for leave under both the Emergency Paid Sick Leave Act and the Emergency FMLA. As Teresa mentioned, the emergency FMLA is that is the only reason how and why they can be eligible for those expanded benefits is because of a childcare situation. So in this example, the employee would be entitled to the full 6 weeks of paid leave at their normal rate of pay, or at 2/3 their normal rate of pay, excuse me, up to $200 a day. And then the first 2 weeks is covered under the Emergency Paid Sick Leave Act. The remaining 4 weeks is covered at the under the Emergency FMLA. And so in this scenario, at the end of the 6-week period of child care closure, the employee is going to have a total of 6 weeks remaining for any other FMLA qualifying reason for the remainder of the year. One question that we've been getting is that, under these emergency paid sick leave or emergency FMLA provisions, does it mean that an employee gets more than 12 weeks in a year? And the answer is no. So if, for example, an employee exercises their right to take emergency FMLA, they're going to use up a chunk of that entitlement under the FMLA. And so, for example, if they have a qualifying condition later in the year for a personal reason, their child care closure leave is going to apply against those 12 weeks. Okay, I'm going to give just one more example here, and then we'll get back into some substance. So we have an employee in this situation who's tested positive for COVID-19, ordered to stay at home for the next 14 days, 10 of which are business days. A week later, the employee's daycare closes, and in this situation, is the employee entitled to another 80 hours under emergency paid sick leave, or would the EFMLA start with an unpaid 10 days or supplemented with PTO? Well, in this situation, if the employee used 10 days of pay under the Emergency Paid Sick Leave Act because of quarantine, the employee has exhausted that emergency paid sick leave benefit. If the daycare is closed thereafter, the employee would be eligible for EFMLA, but it would be subject to a 10-day unpaid period because they've already exhausted that emergency paid sick leave benefit. Now, in the situation of the 10-day unpaid period under EFMLA, the employee would be permitted to supplement that 10-day unpaid period by using, for example, their PTO, but it's got to be at their option. An employer cannot force an employee to take PTO or any other unpaid time in lieu of these new federal benefits, but if an employee wants to do that, they certainly can. So in this situation, we would have, let's just say the employee did go ahead and take PTO for the 10-day waiting period. Emergency FMLA would then kick in for an additional 10 weeks, but again, subject to the 2/3 pay limitation, a $200 a day cap, or the $10,000 aggregate total that Teresa had mentioned earlier. I'm going to, audience members, I'm just going to skip over scenario number 3 in the interest of time here. But Teresa, as she mentioned in a couple of slides ago, to the extent that an employee is laid off or furloughed, he or she is not going to have any eligibility for either the emergency paid sick leave benefits or emergency FMLA, for the simple reason that if the employee is on layoff or furlough, they're not working, they have no need for leave, and as a result, those leave benefits are not available to them. Okay, a couple of things, and these are I would call them more nuanced issues under the Family First Act here. So first and foremost, what do we do, or how do we deal with overtime hours? So first, the thing to understand is that employees are entitled to use their new, I'll call them their new benefits under the law, at the same hourly increments that they otherwise would work. So for instance, if you have an employee that works more than 40 hours a week, let's just say they work 50 hours a week, and I'll highlight that in an example in a moment, they're going to be eligible to use or burn their new benefits at that same rate. So in other words, the 50-hour-a-week employee is going to be able to use their emergency paid sick leave benefits at that 50-hour-a-week rate. Same holds true for emergency FMLA. They're going to burn those hours at the same rate. However, the employee is not entitled to their overtime rate of pay. So all we're looking at from a weekly hours standpoint is how quickly they're burning that benefit, and obviously they're entitled to their regular rate of pay, or the 2/3 rate, depending on the reason for the leave. But bear in mind that, for example, with respect to the Emergency Paid Sick Leave Act, there is a cap of 80 hours on their entitlement. So if we use that same example of someone at 50 hours a week, they're only going to be entitled to a portion of that time the second week, and I'll highlight that quickly here with an example. So again, we've got someone who regularly works 50 hours a week. Under the EFMLA, an employee must be paid 2/3 their normal rate up to the caps for all 50 hours in that week. And that would hold true to the extent that they continue to take that leave week after week. Under the emergency paid sick leave provisions, because of that 80-hour cap, the employee can take 50 hours of paid sick leave the first week, but they're only entitled to 30 hours in week 2. In other words, just because they work 50 hours a week doesn't mean they're going to get 100 hours of emergency paid sick leave. It's always going to be subject to the 80-hour cap. Teresa, I think this is you again.
Thanks, Brian. So one of the questions that we have been receiving is how the quote unquote old FMLA interacts with the new emergency FMLA. And as we've pointed out, and it's important to keep in mind, the expanded FMLA does only apply to child care issues. And so an employee may still, though, be entitled to regular or old FMLA because of the employee's own personal condition or a serious health condition of a family member, which could be a qualifying condition under the old FMLA. Now, this would be unpaid leave, but I think it's important to note, particularly for those who are thinking about using the healthcare provider exemption, that even if you say, I'm not going to provide this healthcare worker paid leave under even the emergency sick leave provisions, you might need to provide that healthcare provider with leave if they need to care for a family member or if they are suffering from their own serious healthcare condition. So this unpaid leave may still be available to them. And frankly, some of them may be entitled to unemployment eligibility for that time off. And maybe we'll get to that a little bit later. And there may also be a need to provide a reasonable accommodation to those people as well. So it's important to keep in mind that those old rules still apply. So we're going to move off of the issue of FFCRA for a little bit here and look to some key questions that were posed by the attendees relating to how to deal with your workforce during the COVID-19 pandemic. So one of the questions that we get all the time is, if an employee is taken leave due to exposure to COVID-19, how do we return them to work? What can we require from them, and what should we be requesting from them? And our recommendation is that you request a medical certification, even if it's an informal medical certification from that employee before returning to work, that shows that they are able to return to work safely following that time off. The problem, of course, is that due to healthcare shortages, the employee may claim that they are unable to provide that medical certification. Many different providers are offering telemed options, and I think that you are absolutely within your right to see whether or not the employee can even get in for a telemed appointment to see if they can get that medical certification. But if they claim they can't, then make sure that you are following the certification guidelines provided by the CDC. And we'll go through what those are. And in all circumstances, you should ensure that the employee is consulting with a medical provider of some sort before returning to work. You want to know that that individual has been released to return to work. But let's take a look quickly at what those recommendations currently are from the CDC. And what I suggest to you all here is that you, in addition to tracking the DOL.gov website, you also make it a favorite to continue looking at the CDC guidelines, because these are being supplemented on a regular basis as well. And if you click through a lot of the different provisions, it provides you with really good guidance on what to do within the workplace. One of those things is relating to returning employees to work. Obviously, the first way to do that is test-based, meaning that they have been subject to a test and then subsequently cleared, either because they do not have COVID-19 or they've waited out the appropriate quarantine time. The second is a time since illness onset. And the third is the time since recovery. Under number 2 and 3, and these make employers a little bit uncomfortable, but the CDC is saying that if you are at least 72 hours out since recovery and at least 7 days since symptoms first appeared, you should be clear to return to work. And if you are comfortable following those CDC guidelines, those are the current guidelines for returning employees to work. And Brian, I think
Teresa, if I
I'm
could
passing it back
just
to
jump
you.
in. Oh, yeah, just to jump in on this, the current guidelines, and I just want to underscore what Teresa said. Particularly given the nature of your industry, it's critical that you are regularly reviewing the CDC's website. But just like everything we're dealing with these days, the guidance is changing, and it's just something that, you know, I would literally suggest that you're looking at the CDC and the Minnesota Department of Health guidelines every day to see if there's new updates. The current CDC guidelines that are out there are dated March 16th, and they're out there on the website. I wouldn't be a bit surprised if those guidelines are updated. I'm referencing guidelines that are specific to healthcare workers, and also the Minnesota Department of Health, as of March 19th, has issued specific COVID-19 recommendations for healthcare workers. I would suggest going on the Minnesota Department of Health website also on a regular basis, but minimally, you should be consulting both the CDC and Minnesota Department of Health guidelines in any circumstance where you have an employee who's suspected of having COVID-19, who has COVID-19, and you're looking at issues as it relates to return to work. A lot of the questions that have popped through from audience members relate to this very issue. Under what circumstances can I return an employee to work? And I would say that it's critical that you're following the guidelines out there. And if there's any ambiguity, you ought to be reaching out to the Minnesota Department of Health for guidance or clarification. Okay, so a few issues here. First of all, with respect to recruitment and hiring, if you are in the process of hiring employees, which I imagine you are, all things considered, can you screen new hires for COVID-19? And the answer from an employment law standpoint is yes, you can. The U.S. Equal Employment Opportunity Commission has come out with some, I'll call it informal guidance, indicating that COVID-19 testing of new employees, although considered a medical test, is permissible under the circumstances. So the short answer is you may appropriately screen new hires from COVID-19, and that makes entire sense to me. What about, I've received a question or a couple of questions with respect to whether applicants for employment are considered essential workers under the governor's shelter-in-place order. I've read the governor's shelter-in-place order multiple times. I've also read the federal government's guidelines on essential workers as it relates to critical infrastructure workers. And the answer that I've been giving is that yes, of course, applicants for healthcare jobs must be considered essential workers, because otherwise healthcare providers would be subject to a de facto hiring freeze, and that can't be the intent. I've attempted to get clarification from both the governor's office and the Minnesota Department of Health. I've not been successful in doing so, but my interpretation of the governor's order is that yes, absolutely, applicants for your jobs would be deemed essential workers, and therefore they may travel to your location if they have to. However, what I would say is that to the fullest extent that you can conduct interviews either by the phone, through FaceTime, through Zoom, through some other virtual source, that would be my strong recommendation. To the extent that you can avoid having applicants come into your facilities, even for an interview, unless it's absolutely essential that they do that, I would try to come up with ways that you can do it virtually. I have a lot of healthcare clients that are doing exactly that. Although it's not perfect, it's a workable solution. Just a quick note here on layoffs and furloughs. As you can imagine, there are a lot of businesses out there that are laying off and furloughing employees. Given the nature of your industry and based on my communications with healthcare providers, I understand that it's quite the opposite. Healthcare facilities are attempting to actively ramp up. They're at all costs trying to avoid layoffs and furloughs. But if you have those circumstances come up, there are some things that you need to bear in mind with as it relates to exempt status. For example, if you have an exempt employee, a salaried employee, that person, if you're going to lay off or furlough that individual, it needs to be done on a weekly basis. To the extent that an exempt employee performs any work within a work week, you have to pay them their full salary for that work week. So the solution there is that if you do have to temporarily lay off or furlough a salaried exempt employee, you're doing that prospectively on a week-by-week basis. I'm not going to spend any more time on the layoff and furlough issue, just in the interest of time, so that we can get to some questions. I'm going to spend just a couple of minutes here talking about some health and safety related issues. And the first thing to be aware of is that employers are subject to what's called the general duty clause under OSHA rules and regulations. And what that means in practical terms is that you as a healthcare provider, and frankly any business, has a general duty to provide a workplace that's safe for employees. And that's just an overarching fundamental requirement that you can't have a place of employment that's risky for employees to be in. Another thing that is coming up with, I would say, increased frequency is that, to the extent that you have an employee that raises a concern about a health or safety issue, that employee is free from retaliation for raising a health or safety concern. So for example, if you have an employee that comes to you and complains about a lack of PPE, complains about staffing levels, complains that the organization under the circumstances is not operating within the regulations, that employee is free from retaliation for raising those kinds of concerns. Does that mean that the employee is completely insulated from any discipline, possible termination for other reasons? No, of course not. But just bear in mind that I think that we're all going to be entering into an environment either now or very soon where you will be getting more and more complaints from employees about health and safety related issues. And you just need to be mindful of the fact that by raising those concerns, they put themselves into a protected status, both from an OSHA standpoint and frankly, under Minnesota law as a potential whistleblower. So just have that on your radar. Another issue that's coming up in the health and safety context is whether an employee has the right to refuse to work. This is coming up in circumstances where an employee may say, I don't feel comfortable being at work because of these COVID issues. I'm refusing to perform my job. I'm not coming into work. From an OSHA standpoint, it is a very, very high standard for someone to lawfully be able to refuse to work. And in order for that to happen, all of the following conditions must be met. First and foremost, the employee has asked the employer to eliminate the danger and the employer has failed to do so. So that's element number one. In order for an employee to lawfully refuse to work, they have to refuse to work in good faith. What that means is that the employee must genuinely believe that an imminent danger exists and that a reasonable person would agree that there's a real danger of death or serious injury. So breaking down those two elements very quickly, as you can discern, it's a high standard. There has to be an immediate danger of death or serious injury. And I would submit to you that an employee who has a generalized concern about contracting COVID-19 in the workplace doesn't meet this standard. Might there be circumstances in the workplace that would rise to this level and meet the standard? Maybe, but it's just, I want to be very clear about the fact that an employee can't just refuse to work, refuse to perform their duties out of a subjective concern. It's got to meet this very, very elevated standard. And then finally, the last factor is that there's not enough time. So the employee, let's just say you do have someone that refuses to work. The last element is that there's not enough time due to the urgency of the hazard to get it corrected through regular enforcement, namely a complaint to OSHA. So it raises an interesting question as to whether an employee can refuse to work, for example, because of a PPE shortage. And I think that again, it's going to be a fact-specific circumstance, but unless there is an imminent danger of death or serious injury, it's not going to meet that OSHA standard. It's not to say that you shouldn't try to work with that employee and come up with a solution, but as it relates to that OSHA refusal to work piece, again, in normal circumstances, a PPE shortage may not rise to that level. Another question that I've seen is, what if an employee demands PPE in a way that's inconsistent with CDC or Minnesota Department of Health guidance? Well, I think that's going to be a very difficult issue to deal with. But at the end of the day, if you have, if we do experience a PPE shortage, you're receiving guidance from both the CDC and the Minnesota Department of Health. And if you have an employee who asks for PPE in a way that's inconsistent with those guidelines, in effect, you're burning through PPE inconsistent with the guidelines. My advice would be that you don't give it to them. I think that we have to be mindful of these regulation or these guidelines that are coming out, and be mindful of the fact that there may in fact be shortages. And although not a perfect scenario by any means, I think you're just going to have to do the best you can in those circumstances. So we have just a few minutes left here for questions. Teresa, do you want to go ahead and take one?
Yep, absolutely. I've got just a couple actually that I think I can answer really quickly. So one question is asking about staff calling in for homeschool reasons, and they're saying they can't come in and they want to file for unemployment. Can an employer fight this? Well, there are two answers to this. One, if the staff is currently working and providing services and just really calling in on a day-to-day basis, that employee may now, after April 1st, be entitled to paid leave under the emergency FMLA. So that would be one place to look and see if they are eligible. But also, employees are eligible for unemployment if they cannot work because of home care necessity. And so there are two different places that employees can look for benefits there, and you can't really fight that, because if employees can't come to work because of reasons for homeschool, you need to provide that to them, and you either need to provide it paid under the EFMLA or the emergency sick leave, or they can have unemployment if that time runs out. So that is one thing. You can request, however, certification from them to confirm that they are actually in need of that. And that could come in the form of a letter from the daycare provider, a letter from the school, some sort of public announcement that the school is closed, and then a certification from the employee that they don't have anybody else to care for the child. Another one that has come up over and over is a question regarding employees who are taking leaves of absence based upon underlying health concerns, meaning that they are in an at-risk population. Maybe they have asthma or lung cancer or something along those lines. And what can you as an employer do to manage the situation? So that raises a number of different questions, obviously. And if that individual, and I'll take the example of a high-risk individual, high risk for COVID-19, if that person has sought medical care and the healthcare provider has said that that person should self-quarantine and remain in isolation to avoid exposure to other people, then that individual very likely qualifies under the emergency sick leave provisions, so the original 80 hours of paid leave, and they may also be eligible for unemployment after that paid leave runs out. And so what I would do in that instance is determine whether some of the management staff can actually work remotely and set them up to work remotely, if even on a part-time basis, to get the benefit of those management staff, and then also to keep them engaged in the organization during the time that they are unable to be in person. Brian, back to you.
Yeah, I'll just answer a couple of quick ones as well. Question has come in whether there's going to be an increased potential for workers' compensation claims as a result of COVID-19 issues, and the short answer is yes, absolutely. I think that it's quite likely that to the extent an employee contracts COVID-19, he or she may contend that it was a result of a workplace exposure. And in those circumstances, file the claim, the work comp claim, just like you would in any other circumstance, and your work comp provider or administrator will go through the process of evaluating whether and to what extent there's workers' compensation coverage. So the short answer is file the claim, let the work comp provider or administrator run through their process and make the determination. Another question, and this relates to something Teresa just mentioned, that frankly is extraordinarily difficult, and that is employees who come to you with generalized concerns about contracting COVID-19, or they have various other issues going on in their life, and they're requesting time away from work. They want to work from home. They can't work their regular schedule. You know, to be honest, yes, we have to look at all of those issues as potential requests for disability-related accommodations. If it's a personal health issue, we have to look at the issue of whether it's a potential FMLA covered claim under old FMLA. But I think that it's quite likely that you all may reach a point where you're going to have to start taking a more aggressive stance on these kinds of requests. And you may, unfortunately, have to take on more employment law related risk than what you're used to taking on in order to meet the needs of your residents and patients. I just think that if the situation gets worse, there's going to come a time when staffing is going to be desperate, and you're going to have to make some of those difficult decisions as to whether you can afford to have people away, unless there's a pretty clear-cut disability-related reason or personal health reason, as Teresa mentioned.
Thank you, Brian and Teresa. I think we need to wrap up in the interest of time. And I know that there are questions that we did not get to. The webinar allows us to look at the questions that have come in. There's a log of them. Staff will take a look at them and figure out how we can get answers to those questions that were not addressed. So Brian and Teresa, thank you so much for the excellent job that you did providing important information and familiarizing our members with this important federal legislation. On behalf of myself and the presenters and staff at Leading Age Minnesota, thank you so very much for the great care you are providing to those you serve, their loved ones, staff, and yourselves. Don't forget to fill out the evaluation that we send along, and thank you so much for participating, everybody. Have a great rest of your day. Bye-bye.